we've got some time left. We're going to go to some questions, and the ground rules for the Q&A go something like this. I'm going to present a question to one of the speakers to start out, and then I'm going to ask the other two members of the panel if they would like to weigh in, and we'll proceed as time permits. So we're going to start with our first question to Dee Bansal. Dee, what are some examples of recent enforcement actions against no-poach agreements?
Thanks, Val. Yeah, that's a great question. So, as I previewed a little bit in my presentation, there has yet to be any criminal enforcement filed by the Department of Justice, although there are some reports that they are engaging in criminal investigations as we speak. The department has brought a number of civil actions, and state AGs have been very active in this area as well. The DOJ, one of its recent enforcement actions was against rail equipment suppliers, and they recently reached a settlement with Norbrems and Westinghouse Air Brake Technologies to resolve the department's lawsuit that the companies had for years been maintaining unlawful agreements to not compete for each other's employees. Interestingly, the department has also been filing a number of what it calls statement of interest in private litigations, trying to shape the future of the way these laws will be enforced. And I should mention there is also quite a bit of private litigation in this area, a lot of them in sort of the franchisee world, but certainly not limited to that fact pattern. And just this year, there was a class action that targeted Saks Fifth Avenue and the luxury retailers that lease space within the Saks Fifth Avenue department stores. And according to the complaint, plaintiffs alleged that Saks Fifth Avenue and the retailers had entered into agreements that restricted the retailers from hiring Saks Fifth Avenue employees. And the argument there from the plaintiffs was that these agreements reduced competition for luxury retail employees, which then, of course, led to suppressed wages. So that's a little sort of nutshell of what's been going on in this specific area.
Thank you for that, Dee. Do any of the other panel members have any other things to say about the enforcement actions against no-poach agreements, or should we go on to a first question?
Sal, this is Todd. I would like to comment on and follow up on Dee's comments about this area. Since October of 2016, antitrust practitioners have been waiting with bated breath for the Department of Justice Antitrust Division to do something that is substantial in relation to labor markets. There was a promise made, and we haven't seen the delivery of it, so that there's good guidance that practitioners in this area in the United States can hold on to say, yes, this is a per se violation rather than a rule of reason issue, and you could advise clients accordingly that these are incredibly important things to avoid. We'd love to see the Justice Department follow through on its promises of active enforcement in this area if they intend to do so, or maybe modify its position that these types of agreements on wages and in the employment market, including no poaching agreements, are to be judged under the rule of reason. Maybe during this COVID process, the Department of Justice will give us some more direction so that practitioners know concretely what direction enforcement will take at the federal level.
Thank you for that, Todd. Fabian, did you want to say anything about the enforcement actions issue?
No, at the moment, I think it's good.
Okay. We're going to get to a fresh question for you then, Fabian. But first, I'd like to issue for our attendees, especially those seeking continuing education credit, the fourth and final of today's secret words. Secret word number 4 is service. SERVICE, service, is secret word number 4. Now, you know how this works. Jot it down and fill out the survey that we're going to be sending to you when the webinar is complete. And we will then, at that point, have you eligible to get your continuing education credit. So the fourth and final of today's secret words is service, S-E-R-V-I-C-E, and thank you all for your attention to these secret words. Okay, first question now to Fabian. Regarding the European Commission approach, is there a difference between the EC legal position on European Union level and those on the national competition authorities on the national levels?
Yes, thanks for the question. This is a very interesting question because the interaction of the different legal systems is in Europe, in the European market, is very complex. So on one side, you have the competition laws or antitrust laws on the national levels, and you have the European Union law, which is based on the Roman Agreement, which is covering the whole market. So as long as national authorities, the measures of national authorities only put pressure on the national market, they are free to do what they want. But as soon as they somehow affect the whole European market, they are bound by the European Commission. So what happens in the today free markets in Europe, actually almost all competition issues somehow affect the European Union market. So there is a close interaction, but still the national authorities, they want to be free to do or show also their own measures. And for sure, in the European Union, what you see is that every country, though they belong together, they look for their own advantages. So when you look at Italy, they try to support the Alitalia, or other industries which is normally would fall under the scrutiny, antitrust scrutiny by the European law. Now during the crisis, everybody is a little bit relaxed. Not only the law is relaxed. So the European Commission at the moment is not interfering. On the other hand, you have this European competition network where also the EFTA states are included. They are more free than the European Union countries, but they still somehow belong to the European market, Norway, Switzerland, things like that. In Switzerland, what you see is that though they actually issued the joint statement by the ECN, they didn't provide, by the way, as the German authorities, they didn't provide a temporary framework. They say they will do it on a case-by-case basis, decide. So, and this is also very unusual under European law because, in contrast, for example, to the common law of America, the European law is Roman-based. So, without clear law-based rulings, it's difficult to enforce any rules. So it's a complex question, and it should be carefully considered by external antitrust counsel in each case of a company.
Thank you for that, Fabian. Unless Todd and Dee want to go and have a comment on that question, I have a fresh question that I'd like to ask of all of you.
Nothing from me.
Nothing from me, Sal.
Okay, so Todd, we're going to start with you first on this question. It's going to be the same question to everyone in the remaining 5 minutes, so if we can keep the answers concise, we do want to get everybody a chance to speak. How can companies ensure that activities coordinated with their competitors are permitted?
Well, I think this dovetails into the advice given by all three presenters today, that the only way to ensure, if the proper word is ensure, is that companies need to seek legal counsel, and particularly today, before engaging in coordinated efforts with competitors or changes in their pricing structures or models, or the way they implement pricing or make pricing changes. Now more than ever, Antitrust Counsel, Consumer Protection Counsel is necessary to help guide companies to ensure, or to the best you can ensure, that companies are making the right decisions today so that there's not a deleterious effect on the economy, or that the company is not subjected to civil or criminal liability, as a result of that decision making.
Thank you for that, Todd. Dee, what's your thought on that?
Yeah, I 100% agree that this is a time when antitrust counsel can be very helpful. But some sort of practical tips. If you are going to be collaborating with a competitor, consider and document what are the pro-competitive benefits. Limit the type and quantity of information to be exchanged. Limit the information to a certain number of employees. Have a preset agenda to guide the discussion. Never share current or future prices, cost information, etc. And another one is to use the business review process that the Department of Justice has put into place. Right now, they're committed to reviewing requests in 7 days. And so that's, another tool that companies have at their fingertips.
Thank you, Dee. And Fabian, would you like to weigh in on that?
Yes, actually, I completely agree with Todd and Dee, especially if there are collaborations which are critical, even on the temporary frameworks or whatever is provided by the competition authorities. It's important to consult for such collaborations, critical collaboration, external specialists, legal specialists. And again, in Europe, you have this possibility of informal consultation where you file the project at the respective competition authorities. And what is very important, what I really recommend on the European law is this kind of comfort letter, where you can file the project at the European Commission to get a legal assessment.